I'm going to prompt up on the screen a deck to share with you that, again, will mostly serve to keep me on track, but make sure that we're covering all of the important items today that we have to share with you about estate planning. We really want to start with just some basic information about what is an estate plan. I know here as your trusted financial partners, a lot of times we call things plans, and we don't oftentimes get an opportunity like this to talk about specifically what we mean when we say plan. And so I'm thankful for the opportunity to do that today. When we're talking about an estate plan, we're talking here about a reliable set of legal documents that allows you to capture your wishes and intentions about how you would like some things handled during your lifetime, how you would like some things to be handled after. And a comprehensive estate plan is a set of legal documents. It's not one document. It's a set of documents that work together to express your wishes and intentions. And what makes it comprehensive is that a plan can cover three principal areas. One, your healthcare decisions, how you want things handled if you can't make decisions for yourself, how you would like financial actions and transactions handled or supported if you need assistance or you need somebody to handle matters financially on your behalf. And then the third component is the opportunity to create a legacy through a set of documents or a document that defines your wishes and intentions personal to you about how you would ultimately like your estate to be managed and handled and distributed when the time comes. So the goal is comprehensive so that all aspects are covered, so that there's some relief in knowing that you have a plan in place for any circumstance or life event that could present. So what we're going to do today is talk a little bit about what each of those documents is, what they do, how they work together in some cases, and the options that you have to create a personalized estate plan that is specific to you and helps you protect what matters the most to you. So I want to start with the healthcare directives documents that I mentioned a moment ago. We're going to start with the documents that do provide support, provide protection, and provide resources during our lifetime. And that starts with the healthcare directives. If I have a medical event, temporary or long-term, and I'm unable to make decisions for myself, I'm able in healthcare directives to provide specific instructions for my healthcare providers of what it is that I want, what it is that I don't want, and give them some guardrails or some guidelines for what my preferences are for how I am treated, again, in the event that I can't speak for myself. Now, the other tool that is built into these healthcare directives is that it allows me to authorize someone to communicate with my care professionals and facilities about records, about my care, about making sure that my wishes and intentions for my care are being followed. And it authorizes a trusted loved one or a series of individuals to be able to work with those professionals to ensure my wishes are being carried out. With a financial power of attorney, it has a very similar effect and opportunity. I can appoint a trusted loved one to be able to interact with the credit union if I need a transaction carried out and I'm unable to manage that myself. Now, that may be for a lot of different reasons that I want to have that backup in place. Maybe, I am traveling and I'm unsure about my ability to get online to be able to manage my account directly. And maybe I need to send somebody in the branch to handle something. I can appoint them through the financial power of attorney to go in and have the ability to take care of that. Or maybe I'm events are happening and I just want to have some help. I'd like to have somebody be able to assist me with these things. And in order to do that, they need to have, I need to appoint them and they need to have the authority to act and transact. And so a financial power of attorney enables me to empower someone I trust or with backups if I feel comfortable with that, to make sure that those things can be carried out seamlessly. Again, at my direction, and with the information that I've provided in the documents about what their authorities are. And then there are the components of the legacy documents, or those documents that contain my wishes and intentions for the management or the distribution of my estate when the time comes. And there are two common tools. They're both listed on the screen. A revocable living trust and a last will and testament are two of those legacy documents that can be options that I choose to decide how I want things to be handled. And there are specific differences. Usually the first question that pops into the chat is, what's the difference between a will and a trust? So I want to talk a little bit about that, and of course be prepared to answer any other questions that you have. But the simplest way to define that is it's about how much control we want or need to have over how our legacy is managed. So I'll talk first about the will. I can create the will now, again, appointing a trusted loved one who is going to serve as what's commonly referred to as an executor or executrix, or in some states it's called a personal representative, who will take that document and follow those instructions. It's like a checklist, so to speak. They'll go down the list and make sure that all of those transactions, those outbound transactions, are carried out, to make sure that the gift that I wanted to give to a specific charitable organization, or a specific piece of property that I wanted to have carefully delivered to a specific heir, all of those outbound things are what they take care of for me. A will also enables me to nominate guardians if I have minor children, or to make arrangements for the care of pets. There's elements and aspects of it that I put it in the will, and then in the event that it needs to be facilitated, my executor has the authority that they need to take care of those things to manage the closure of my estate or the completion of my estate. With a trust, this is slightly a different kind of tool that's available, where the trust can be signed now but goes into effect when I pass. If I choose to create what's called a revocable living trust, it goes into effect as soon as I sign it. And it becomes an entity. The trust is an entity that I, as the creator of the trust, have full control over. So I decide which provisions are included in the trust. I maintain full control over the assets that I title into the name of that trust. And then I'm able to appoint a successor to me, so that when I'm no longer able to manage the assets that are in that trust, there's someone who can step up, again, a trusted loved one who can step up and follow those instructions and carry out those details of what I've laid out in terms of how I want things managed and distributed. It is unique in that I maintain full control over the assets during my lifetime. I can use this tool to maybe protect the equity that I have in my home. I have a trust. I am the creator of the trust. So I have my home titled into my trust. If you look at the property deed for my home, it will list the owner as the trust, but it also lists me as the trust, as the settlor or the trustor of the trust, showing that I can still sell that home, I can still retitle it, I can still take a loan against it. It's still my asset. It's just held in the trust. So I can protect my equity in the home by having it titled into the trust itself. It also gives me the opportunity to protect the legacy in a different way. So, for example, not just minor children, but some folks say, I would like to have my legacy distributed to my heirs over time. Maybe I have adult children, but I want to spread this out. The entity of the trust can hold those assets over time, and the successor trustee has, maybe I say, I would like my son to receive a third of his share of the estate when he's 35, a third when he's 40, and the remainder when he's 45. Those are the kinds of control that I can include in the trust provisions to ensure that my wishes to delay that distribution are carried out. For some folks, it's protecting minor children, or their priority is setting aside funds for heirs for education purposes. We work with a lot of members who maybe they have a beneficiary or an heir who has some special needs. And with some situations, maybe that individual is currently receiving daily support or care through grant-funded programs or government-funded programs, where if they were to receive an inheritance from my estate, their eligibility to receive that daily care could be at risk because it would be considered income. Well, the benefit of the trust is I can provide for that heir by having the estate or having the trust be the retain ownership of that asset, and for the successor trustee to apply and support that heir with that share for their benefit, so that it doesn't impact their eligibility for the other services that they're receiving. So in short, it's another short way to explain it is a will says who gets what. The trust says who gets what and how. The and how is that control feature that's available with a revocable living trust. Again, as the creator of the trust, you do not lose any control over your assets. You still have the ability to buy, sell, trade, do whatever you would normally do as the owner of your property. Any questions about that? I don't see any in the chat, but I just want to take a pause in case there's someone's inspired to answer a question. Please feel free, and I'll keep an eye on it. I know Nicole is too. All right, we'll carry on. So a lot of times, we have misconceptions about estate planning. We and all have this or have seen or experienced. Usually it's on a screen, big or small, where we see that Hollywood version of, there's a person with a big black leather notebook sitting behind a big wooden desk in a law book lined office with big furniture, and they're speaking a language, and there's a group of family members huddled around the desk waiting to see how their lives are going to change. That's typically not, it's very good for the movies and TV, but it's typically not how it works. But it gives us a lot of reason to think, well, this is for something that's specifically for folks that have lots of zeros on their bank balances and have tons of property and have assets that I don't have. That can be true in some ways, but the reality is if I need somebody to help my care professionals make healthcare decisions for me, it doesn't really matter how many zeros there are on my balance sheet, right? If I have the opinion that, well, I've already shared with my inner circle what it is that my wishes and intentions are. That's a good thing, that they know what your wishes and intentions are. But over time, sometimes things change, right? Documents can change, opinions can change. But if I haven't provided those trusted loved ones with the authority to act. It's great that they know, but if they don't have the authority to act in those legal documents, they may have to go through a court process in order to get that authority. We also often, when we're thinking about legal services, we think, oh my goodness, this is going to be so expensive. And, maybe when I get my tax return, or maybe when I'm thinking about moving some assets around, or maybe if I get a bonus at work, and it's really easy to put off. And, that's just life, right? And so what we've tried to do is come up with some ways to overcome some of those misconceptions and bring to you a solution that is easy and affordable. It's supported. There's folks that can help answer questions so that you can make sure that you have a resource and a backup plan in place that gives the folks in your inner circle the authority they need if they need it, so that you can have the benefit of that relief. So I want to talk for a second about what happens if you don't have a plan. I mentioned that court process. It's called probate. And that can apply during our lifetime if someone is trying to get authority to act, or after if someone is unsure about how to handle the distribution of an estate. In the middle of a life event, going to court is probably not optimal. I mean, it costs money, it takes time, it can be very intimidating. Really having a plan in place that outlines and details what our instructions are can help us and help our loved ones avoid having to go through that process. So we're helping eliminate the guessing game of who's going to do what and what would Linda want. Like, it's all there. It's all there. And I'm providing instructions. I'm informing. This is what I want. This is what my wishes and intentions are. I'm giving them the authority to act if they need it. I'm providing all the directions about how I want things handled. I'm making sure that when my loved ones approach my financial institutions or my asset holders, they have the tool, they have the document to bring in and say, I'm the one that has the authority to act, so that the process is easier for the credit union and the other financial institutions that we have assets held with. I can use the tool to protect the assets and equity that I have. It can help avoid probate, and I can make sure that my wishes and intentions are captured in a way that align with what it is that I want.
Linda, before you continue, there was a question that did come in, and it was asking about, will you be discussing irrevocable trusts?
Yeah, irrevocable trust. Well, let me do that right now. So, yes and no. Irrevocable trusts are a different type of trust. Revocable, irrevocable. Revocable, as I've described, there's a lot of flexibility with it. You're really in control, right? With an irrevocable trust, once that ink is dry, you really have no control. It's a different type of trust that serves a different need. So if you're looking at a generational legacy or a way to distribute assets in a fixed way that cannot be changed once it is established, that's what irrevocable is, right? It is a type of trust that requires, and I'm being specific about requires an alignment with tax professionals and CPAs and attorneys who can make sure that if you're going to create a revocable trust, because it is very rigid, there's not a lot of flexibility with it, you need to make sure that is aligned across a lot of different disciplines: tax, accounting, all of those related professionals would be involved in creating that type of trust, because once it's done, right? There's a lot of different elements and aspects of it that can feel very permanent. And so you want to make sure that it's actually, you're getting advised on whether or not that's in the best interest of yourself and your estate to proceed with an irrevocable trust. It's not a product we offer here at Legal Karma, because we believe that it is the best thing to do if you're interested in an irrevocable trust, is to get advice from your financial professionals and legal professionals before making that decision. There's another question I see as well as regrets for having recently gone through probate. Please figure out a way to get your estate in order. Yeah, I can't overemphasize how challenging probate can be, and really to put it in very human terms. We're already going through a lot when we're going through those life experiences, and then to add the many layers of uncertainty and intimidation, especially if we're not comfortable with the courts or we haven't had a lot of experience there, it's just it's something you can really save a lot of additional difficulty for your family members if you have a plan in place. Even if you have a plan and there's a requirement that it be recorded with the court, if there's a plan, it's an administrative process. If there's no plan, it turns into something entirely different that is much more stress-filled and some folks very traumatic on top of an already life-altering experience. Thank you, Heather, for your comment on that. It's much appreciated. So what we've tried to do here at Legal Karma and in and through our partnership with Minnesota is come up with a way to provide an affordable, as I mentioned, easy and supported option for you to create a plan that is personalized to you. So we have, when you log into online banking, you have the option to go into the estate planning tool. It's all very price transparent. You're paying for a product. So there's not a lot of hidden charges. You know exactly what you're paying for. You can go through online, answer some very direct questions. There's a lot of education and information about the questions themselves. And then we have a team of estate planning specialists who are available to you by phone. They're available through a live chat feature in the questionnaire. They're available to schedule an appointment with you at your convenience if you prefer to just have somebody sit down and go through it with you. All of that support is part of the purchase price for the package. So there's no hourly rate billed at 15-minute increments for service. We want you to get a plan in place that you are confident and comfortable with, meets your needs, is specific to your situation, and that you feel good about that backup plan that you've created and the tools that you're giving to your family members. So that's the option that's available. I've put some pricing information. I remember I'll go back to the beginning. We talked about comprehensive packages. We want to take the guessing game out of it for you. We don't want you to have to go through a list of documents and try and figure out, do I need this? Do I need that? How do I get this? Is this part of it? Is this what I should do? We want to make it as easy as possible. So we have put together packages that are already comprehensive. We've created this interactive tool that you can go through, answer. It's 8 questions. It takes about 3 minutes of your time. There's a ton of education and information about it, and it will help you identify what package will best match up or align with the wishes and intentions that you have. So I highly encourage you, if you're unsure or if you want to learn more, go in and spend that few minutes, look at the information that's there. There's a lot, it's all in plain English. There's no legalese. If you have a question, pick up the phone and call us. There is a very available support team that can, let me get the screen up here. There is a dedicated phone number for Mid-Minnesota Credit Union members. It's on the screen right now. I'll also go ahead and put it in the chat. This number, the member support specialists are available to answer any questions that you have. They can also get you scheduled for a free appointment with the estate planning specialist if you'd like to talk more specifically with someone about your situation. Spanish and English appointments are available. The team is really here to make sure that this process is exactly what I'm telling you. It is easy, it's guided, and it's now. If you go into the system and it makes sense to you, you're not obligated to call. You don't have to have an appointment. You can carry on through the process, and all of that will play out however you feel most comfortable. Again, this is about creating a plan that works for you, and we are here to answer your questions, support you through the process in whatever way is most effective for you. Other thoughts or questions?
Again, feel free to add your questions to the chat section here, and we can get those over to Linda. Now, Linda, if somebody has a specific, situation, they don't want to talk about it here on the WebEx, which I totally understand, your support team that they can call can kind of walk them through their situation and sit down with them, talk them through, and if, kind of guide them into which option, correct?
Yeah, absolutely. So one of the things that quick 8-question tool that I mentioned when you first log in through online banking, that is designed to help you identify, get some information about the types of things to think about during the beginning of creating an estate plan. And what it does is it asks you some questions, and then it provides you with a bullet point list of your responses, and then it correlates them to which product most closely aligns with the things that you've identified are most important to you. I saw somebody asked for the pricing screen back up, so that's back up there. But hang on with me for a minute, Fred, because we're gonna talk a little bit about that pricing again in a minute. We want to make sure that you feel comfortable with that. You will still be able to see all of the other package options that are available. Again, the pricing is always transparent. The opportunity to call and chat with somebody quickly or to schedule a longer appointment, that is all available at no cost, whether you purchase our product or not. So that's why I'm really encouraging, if you're hesitant or you're unsure, you just kind of want to get a sense of, what is this woman talking about? Go click into it on online banking. Look at it, get a feel for what it looks like on the screen, the information you'll find on each screen. It will ask some follow-up questions and give you the answers so that you can help get into the flow of how the interaction works. But again, always want to make sure that you feel confident. That's why we always have support available.
And Linda, one other question that has come up for me as I've talked to members about these products and these packages is, what if I need to change something? Let's say I get the power of one of the packages, or maybe I get all three, but something changes. I have 10 kids and I like 5 of them this week, and next week I like the other 5. How does that work if I need to change something on one of these packages, or are they set in stone?
Yeah, so this is the nice thing about a revocable living trust or any of the other documents that are here. That's a great question, Nicole. Thank you so much. So with the Legal Karma service, when you go in and let's say I go in and I create a will package, and I decide that I want to change the will. As a Legal Karma participant, I can change that will 2 times in the first 6 months, and my price point will not change. There'll be no extra charge. I just pick up the phone, I call the number that's in the chat, and I say, hey, I created these in February. I want to make a change. The team will walk through, make the change, send you the new documents to sign and notarize again. If I've created a trust and I want to make a change to a trust, there is the original trust and trust date do not change, but there is an amendment to a trust that I can create. Let's say, using your example, I don't want to leave the vehicles to that child anymore. I want to do something different. I got an opportunity to donate them to a nonprofit. I want to put that in my trust. I can come back in and I can create what's called a trust amendment. It's not on the screen, but the price point for a trust amendment is $199. It will just identify, I want to make this change, and everything else will stay the same. Where we see most people come with a lot of desire to change is I appoint somebody as my financial power of attorney. They move to another state. And I prefer, and it's not, I can have somebody named that lives in another state, but I prefer to have somebody local. I can come in and update my documents. Again, if it's in the first 6 months, it's not going to require an additional fee. If I come back after the 6 month and all I need to do is update my POAs, I can go for the lesser priced POA package and leave the will or the other trust documents as they are. So yes, you can make changes. We're here to support that. Here's the other thing that's nice about the way the legal karma system is set up. If I come in now and I create a will package and I decide 3 years from now, I want to redo everything. Okay, I want to change it all up. For whatever prompts me. I log back in with my email address. The information that I entered is retained in the system, private to me. We don't share it with anybody. Private to me. I can go back in and make the changes that I want to make and regenerate the new documents fairly easy. So edits and changes are super easy, and we're always happy to help with that. I see questions. Could I give some guidelines and suggestions for choosing the person you would best fit as your successor in the event you don't have a family member? Okay, that's a fantastic question. Thank you, Liz. So for those of us who do not have inner circle, maybe we have family, but they're not readily available or positioned or in some cases willing to serve in that kind of role. With successor trustees, so I'm talking revocable living trust specific, there are in most states professional fiduciaries who are willing to take on that role, where they will allow you to name them as their successor trustee to manage and facilitate the estate. In a lot of states, those folks are licensed by the court. They're private individuals, but they do have licensing standards that they follow up with. There's a couple of different ways to find them. You can do a search for local fiduciaries or estate fiduciaries, estate planners. Pick up the phone and call them. If most will offer to sit down with you and talk about what you're looking for. A lot of them will take a call over the phone. You can find out what fees they charge the estate, that kind of thing, and how that works. So there's a lot of resources available for that. It doesn't have to be a family member. If you have a close friend or someone that you feel confident in naming, it can be a private individual as well. But there are also estate planning law firms, and in some cases, firms that are specifically designed to handle to serve as a trust estate. So those professionals are definitely out there. If there's a licensed person, I would definitely recommend considering that, just because that gives you additional protection, because most folks who hold formal licenses have codes of conduct that they have to follow, and that gives you a little, as a consumer, gives you a little bit more protection as well. The function of a TOD in estate planning. Yeah, so a TOD, for those who aren't familiar, refers to a transfer on death. And there are a couple of different forms of TODs, so I can share with you what I know about that. Fred jumped back in about professional fiduciary as a trustee. Any recommendation? Yeah, I would definitely, you're going to want to go with somebody who's professional, preferably licensed, but I don't personally have a recommendation for someone in your area. So let's go back to TOD for a second, transfer on death. Now, there are some places, if you have real estate property, there are 8 states that you can actually set up what's the equivalent of a transfer on death. It's a type of deed that you can record in the county where that property is located. And when you pass, the beneficiaries record the death certificate, and the property automatically transfers to the folks that are listed on that deed. That is one type of TOD. The one that we're most familiar with or most commonly come into contact with is a transfer on death that we list on an account. So maybe I have, share accounts at Mid-Minnesota FCU, and I have filled out a form and signed and notarized it that said, on my passing, I would like all of this to be any balances to be transferred to my son. And my son would then have to go in, present who he is, and go through whatever administrative processes are necessary. That is specific to that account, right? That is great. We always encourage everybody where you can with the asset holders that you work with, your financial institutions. Yes, it's good to have a TOD in place. It makes things clear. It makes things directed, not only for your loved ones, but also for the credit union. What a TOD doesn't do is ensure that all of your assets are covered. It also doesn't provide that authority or appointment to act in other areas like that comprehensive estate plan will. So let's say I forget about that account that I opened, I forget to put a TOD on it, or I have tangible property, my home, the goods inside my home, my car, my pets, right? I love my dogs to death, but they're tangible property under the law, right? I want to make sure that those things are covered as well. And there isn't a TOD option for those things. Maybe I have collectibles that I want to make sure are guided in a specific way or protected in a specific way and delivered to a certain heir. Or I have other things that I've inherited that I want to keep in the family. Those are the kinds of things that go beyond a TOD that an estate plan can help with. And really that those during my lifetime features are equally as important. So I hope that answered your question. If it didn't, please put another one in the chat. I made a promise to Fred. I don't want to get away. But I know you asked about the pricing. And so, one of the things that is really great about Mid-Minnesota and the partnership and the way that they are as committed as we are here at Legal Karma about getting an affordable solution for estate planning into your hands is to offer this discount. So when you get to the pay point, when you go in and you go through that quiz and you've answered the questionnaire, you've selected a package and you've answered the questionnaire and you get to the pay point, there's an option to enter a discount code. This promotional code is available to you as a valued member of the credit union. It will give you 25% off of any of those package prices that were just displayed on the screen. So again, we want to make sure that you are confident and comfortable in having a plan. We want to make it as easy as possible for you to get a plan. We want you to know that we are here to support you in this process and here to help in any way that we can. So please take advantage of the opportunity to go through that 8-question interaction, learn more, and know that once you select a product, you do have the option for this discount.
Thank you, Linda. Any other questions? Feel free to add those to the chat and we can get those over to Linda and she can get those answered. Linda, if you wanted to maybe go back to that phone number screen, just so everybody's got that, so they know where to log in or to contact us or to contact you and get their questions answered and get started on the process.
Absolutely.
We have another question from Fred. I have TOD set up on my property, but an attorney who recently reviewed my documents recommends against these.
Yeah. Everybody, the attorney, I'm sure, as the basis of their recommendation, they're looking at the whole picture, right? Obviously, I'm they are putting together, they're there to serve you. There may be other factors or considerations that they are using as the basis for the recommendation. It is an option in some states, others it is not. So I always like to mention it. There are different things that may be specific to your wishes and intentions that are part of their recommendation. So I always like to let people know that that option is available. But again, it really, this is a personalized process. A lot of times we think, well, I'm just going to go online and I'm going to get like just some stock, somebody's going to send me what they send everybody else. Well, that's not how this process works here at Legal Karma. And that attorney is there to serve you and make their best recommendation. So that could be based on a lot of different factors.
Linda,
we don't offer deed services here, so that would be something that you would work with either a real estate attorney or if it's applicable, a title company, or do yourself. Yeah.
Would you recommend for Fred to maybe call in and just talk through it and see where things maybe, like you said, a TOD is more on an account-based level or a property-based level, talking with somebody on your team about kind of that blanket type of a situation?
Yeah, we're always happy to have a conversation. Again, there's no charge for that conversation. We wouldn't be in a position to advise like the attorney is, but we can certainly share all of the information that we have and answer any questions that anybody has. Always happy to do that.
Thank you. Of
course.
Well, I don't see any other questions that have come in. So, I mean, we could maybe be nice this afternoon and give people back about 15 minutes of their lunch breaks.
Can I take 30 seconds? Because that question
Absolutely.
is inspiring one other thought. One of the things that comes up a lot, folks will say to me, well, I'm going to give my house to my kids. Can I just put my kids on the house now? And yes, that is an option. But if you add them as owners now, they are now responsible for the taxes with you. They are now, if someone who's an owner of the property gets in a car accident and somebody wants to make a claim against your house because an adult child got in a car accident, it's now their property and subject to that as well. So there are a lot of reasons to do it. For convenience sake, there might be as many reasons not to do it. A trust can help you by having the asset held in the trust, and then it can be directed however you choose, and it eliminates those issues. So just a quick afterthought I had there that Fred inspired.
Great point. All right. Well, on that
yes,
note,
please don't hesitate. I was just going to say, please don't hesitate to call in with any questions anytime. We're always happy to help.
Wonderful. On that note, we can give everybody a few minutes back on your afternoon here. We appreciate you all coming on and joining us. Hope this helped and answered a few questions for you. And if not, of course, there's many resources with a phone number that you can certainly call, have a free chat with Linda and Linda's team, and get some more additional information for you. Linda, we thank you for your expertise and your time this afternoon. We generally very much appreciate it.
Thank you all so much. I hope you all have a great day. Please be in touch. We're here to help.
Thank you, everybody.